Seated. The court is ready to hear argument in 080613 Nafta Traders against
Please the court. Mr. Busch will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court and good morning. The Court of Appeals erred when it refused to enforce a critical provision of the parties' agreement to arbitrate, thereby undermining the parties' right to choose in contract how they wanted their dispute resolved. The arbitrator in this case ran wild, exceeded the authority that was given to him by the parties, did so by taking an employment discrimination case which falls in a very specific paradigm, a disparate treatment reduction in force case, treated it more like a sexual harassment case, got the totally wrong result, and then fashioned a remedy that does not exist either in law or in equity.
Which is exactly what happened in Hall.
Absolutely. And obviously it's our position that, first of all, that Hall does not apply to the Texas Arbitration Act, obviously begging the question of which act applies.
Well, and let's agree it doesn't. But why shouldn't we follow the same law so that we don't have two separate bodies of law on the issue? What's different about the TAA that should mandate that we go a different direction?
Well, Your Honor, consistency is an important value. I submit it's secondary to the value of honoring the parties' agreement because that underlines the whole public policy of arbitration, and why I think that the Hall rule, if carried too far, and the rule that the respondents ask you to do will deeply damage arbitration in this state. If the NAFTA's traders, the petitioners of this world, if the citizens of the state of Texas find that the courts are not enforcing their agreements to arbitrate the way they structure them and only gives them part of what they thought they were getting, and find that they're in a form that can be more arbitrary than perhaps what they feared when they were in court, the smart people who draft these arbitration clauses are going to quit drafting them. You'll see jury waiver clauses in re prudential. You'll find that we'll be in court with contractual limitations on what the court ought to do.
And what's wrong with that?
Well, I think it's always been the express public policy of the state to encourage arbitration. And
what is the advantage from your client's point of view, or from a business point of view, from a party's point of view, of having a provision that sends a dispute to arbitration but then leaves open basically full appellate review? Why not just go to trial in the first place?
Well, there are a lot of advantages, real and perceived, about arbitration in terms of expense, in terms of how fast the process works, in terms of confidentiality and how less public it is, in terms of, in certain types of arbitrations, in terms of expertise, and I'm thinking from my own experience, like there's a certain type of securities arbitration of customer complaints against their brokers, and there's a whole regime of expert panels dealing with securities and stock trading. So there are different reasons that the parties want to go to arbitration. That are very practical, and let's be real, one of the really biggest ones is there's a fear of, if I may use the term, arbitrariness on the part of juries, and a lot of it's a flight from juries, and yet sometimes, unfortunately...
about a jury waiver?
Well, and that would be a solution to that particular issue, but in response to the question of the various reasons why it makes sense for parties to agree to go to arbitration, that's one of several good reasons.
But it seems to me that much of those, or many of those, are lost or at least compromised if you then go back into the legal system and go through the appellate process.
That's all outweighed by the benefit, I would think, from the parties of knowing that the arbitrator isn't totally free to be completely arbitrary. I mean, let's face it.
Completely arbitrary?
I'm sorry?
What was that you said?
For the arbitrator to be totally arbitrary. If there's no check at all on what the arbitrator does, as there is, for example, with juries, then both parties, unless they agree to limit his powers, which they have the right to do, but if they don't limit their powers, they're basically asking the arbitrator to do virtually anything the arbitrator wants. And if the parties agree to that, then they should get that. But in this case, the parties didn't agree to that. They asked for something very different.
Do you know if there has been reaction to the Hall case contractually by waiving jury provisions, waiving juries and selecting particular forms, things like that?
I can only tell you my practice, what I tell my clients, and that is that frankly, particularly in light of the Hall case, and even before the Hall case, you might seriously consider waiving a jury and staying within the court system than going to the arbitration system. Getting back to your previous question, a lot of the reasons that parties go to arbitration sometimes are perceived and not real. Arbitration, unfortunately, in many cases has become a process as expensive, as time-consuming, and as litigation. You go to AAA complex litigation rules, you're taking depositions, you're doing all the same stuff. And you've got a decision maker, assuming there's only one who's charging about $400 an hour, and a clerk, if it's a big enough case, charging about $2,000. Whereas we've got really good judges with clerks, you get in there for $200. So, again, what parties aren't doing is hopefully a calculated decision based on the realities of arbitration and the realities of litigation. And if the system is to work and if arbitration is going to have a proper part in it, the parties have to have the freedom to craft the kind of arbitration that they want. And you see, if the Act forbids it or not, there's nothing in either the Federal Arbitration Act or certainly not in the Texas Arbitration Act which says that the parties are forbidden from limiting the powers of the arbitrator. And there are cases out there, not that go to this extent, but there's certainly cases out there where you can limit what kind of evidence the arbitrator hears, you can limit what kind of remedy the arbitrator can render. In fact, that's specifically in the Texas Arbitration Act. And so there's certainly nothing from interpreting the Texas Arbitration Act and interpreting the agreement of the parties in this case that prevents the parties from doing so. And by extension, I think if the language are crafted the way you just suggested, Justice Hecht, I think that would also withstand scrutiny.
As I understood Justice Hecht's question, your modification would be of the court's ability to act. You would, in other words, you would kind of be going against the statute if you precluded confirmation, whereas the statute says it shall confirm if. You know, it's more or less that way. Whereas, as I understand your provision in this case, you're not confronting the statute, but you're just saying that the arbitrators exceeded their powers, which is one of the grounds in which the award could be vacated.
You've helped me understand Justice Hecht's question. But
Well, I don't know if I understood.
Actually, let me clarify the question.
I frequently question Justice Hecht, but I'll try to understand his question.
No, I was asking whether the parties could restrict themselves, that neither would apply for confirmation unless the judgment were such, unless the award were such that had it been the judgment in the case, it would be affirmed on appeal, and therefore, if somebody did try, moved for confirmation, and you took the position that wasn't the case, you'd sue them for breach of contract, and then you'd get your review.
All right, I think I understand you better, and I think my answer is the same.
I think it is.
Okay. I'd like to briefly discuss an issue that came up very late in this case, and that is whether we're here discussing the Texas Arbitration Act or the Federal Arbitration Act. It came up for the first time in this court And no doubt because while this case was pending on appeal, and to be more specific, after submission, but before the opinion of the Dallas Court of Appeals was reached, the Hall Street opinion came down. It's our position, quite obviously, that it's too late to make an argument that the Federal Arbitration Act applies and preempts. I'm not sure either party's done a really good job of helping the court deal with that distinction. I think we lumped them together. The Federal Arbitration Act does not apply in this case. The reason it doesn't apply at all, much less preempt, is first of all, of course, the defendants are judicially stopped from asserting it now. They didn't just make a legal conclusion to that effect. They specifically represented to the Court of Appeals, the courts below, that the contract that was being arbitrated did not affect commerce, that the transaction did not affect commerce. That's a factual assertion. That's the predicate on which the legal conclusion is reached. And whether a contract affects commerce or not can be a fact-specific inquiry. And so at this late date, depriving the trial court and the lower courts of making that determination because of that factual concession ought not allow the respondents to in the Texas Supreme Court, change the law.
Let me just ask you real quick. Have any other states gone your way under their own arbitration statutes? Have any of them departed from Hall?
Yes. Both sides, in the form of an exhibit, so I could get it in front of you right now, is just a dead-on-point California Supreme Court case that came out. And I'll discuss it later if I have time. Last night I received, not complaining, a supplemental brief in response from the respondent citing a case law which, according to the email from my office, is distinguishable, but basically the California Supreme Court case just came square down on every issue. I wish I'd seen it sooner because it would have written my brief for me. And as I understand the respondent's position, there's contrary post-Hall authority following Hall in Georgia and Tennessee, but in that case those clauses expressly expanded the scope of review instead of what petitioner did in this case, which is deal with the issue of whether or not the arbitrator exceeded his powers. I'll also point out to you that the California Supreme Court case that's before you as Exhibit A is also a case where it dealt with both issues. It both expressly disagreed with Hall and came down on the side of the exceeding powers language. It did both. And it did it under the California Arbitration Act, specifically, as in this case, noting that the person trying to defend the award had always presented it as the California Arbitration Act applying until the Hall Street case came out. And then it did something really fascinating that I didn't think of. It pointed out that it also took the position that when the party elected to confirm the award in California state courts, it was in effect choosing California law, and federal law did not preempt. And I'll
Any further
what's left of my time.
Any further questions?